Good evening, everyone. My name is Debbie Gould, and I'm the president for the League of Women Voters of Tennessee. And I want to welcome all of you here tonight to hear about a topic that really matters a great deal to us. As you can imagine, the League of Women Voters is extremely interested in making sure that all eligible Tennesseans are able to vote if they want. And unfortunately, we have an extraordinary number of Tennesseans who have been locked out of voting because of a felony in their past. So tonight, we're going to talk some more about it and hear from some very knowledgeable people who really can explain the current state of the voter restoration process in Tennessee and why recent developments have made it so much more difficult for interested individuals to be able to get the right to vote back. So just a little bit of housekeeping first. The audience is muted so that we'll be able to hear from our panelists without distractions. But you can post your questions in the chat and they will be answered after the presentations. The speakers are going to be timed, and the reason for that is that we really want to make sure that we have an opportunity for your questions to be answered. The recordings will be posted on the League's website, which is lwvtn.org, and it also will be sent as a link to everyone who registered for this event. We'll just begin right now and with hearing from Angel Romero Bowman. She is chairperson for the Lonsdale Neighborhood Association in Knox County and a member of the 5th District Neighborhood Advisory Council. And what's more, Angel has successfully restored her voting rights and later on restored her citizenship rights. So we are proud to host Angel here tonight and hear a few words from her about her journey. So thank you, Angel.
Thank you so much for having me. And again, my name is Angel Bowman, and I'm a mom, I'm a wife, and I'm a convicted felon. And so I'm here today to just share a little bit about my journey with you guys, and I'll just go right into it. I know some of you are wondering, why do I feel like voting rights are so important? Voting rights to me is so important because it gives me a voice and it gives me a say in my government, and it is very empowering. But let me just start off and say, I know that some choices that I made a long time ago, decisions that I made some wrong, bad decisions. It cost me my voting rights. That's on me. I did that. And as a result of that, I was sentenced to 16 years on probation, and I lost my rights to vote. Now, I finished my sentence of 16 years on probation. I done everything that was required of me and more. I spent the last 20 plus years helping to build up my communities. I stayed in the same community that I helped to tear down many, many years ago and to help build up those communities. And so I understand that I did something wrong, but I paid my debt to society and I deserve my rights to vote back. Now, let me make it clear. I didn't just complete my 16-year sentence and go right into getting my voting rights back. It actually took me 5 years after the 16 years because there's a fear with asking for your rights to vote back. It was for me, at least, because I was going to potentially rock the boat. And I didn't want to find out that I really wasn't off of probation. That's a fear. And so it took me 5 years to just get with some advocates, get with some people to help me get the paperwork together to get my voting rights back. So I had to go up to the probation office that I had spent 16 years going in month after month. And I was afraid, but I went ahead and pushed forward and persevered, and I got my rights to vote back. And so after voting, and that just was empowering. It helped me to understand that my voice mattered. It helped me to understand that my vote counts. And because of that, I was able to do more advocating in my community, do more activism in my community, because I felt more liberated. I felt more empowered because I felt like my voice mattered. And so I was able to have a say in who was my district person, my mayor, my city councilman. And so that was empowering to me as well. So then years after getting my voting rights restored, I then went full restoration. Now that was going for just your voting rights is a lot less difficult than going for full restoration. I had to get an attorney. I had to approach the very same courthouse in my city. I had to approach the very same courthouse that I lost my voting rights and where I was convicted in many years ago. So I had to face that same courtrooms, and that wasn't easy, to say the least. But I was able to do it. But it was much harder than just getting my rights to vote back. And so, like I said, there was two-part process. First, I got my voting rights restored, and then I was able to get the full restoration of citizenship. But I don't think I could have done it. Now that it's trying to be flipped, I don't think I could have done it because it took me almost 8 years to just ask for full restoration of citizenship versus the 5 years that it took me to just get my voting rights back. And that, I think, if it had been flipped, I don't think that I would be where I'm at today. And I am a very active member in my community. I am like they said, all those things, but I speak up for my community. I've got one of the first inner city schools because I was able to vote. Let me say this, because I was able to vote, because I got my voting rights restored, I was able to approach the city council meetings and the school boards and fight for my community and get the first inner city school built from the ground up in over 50 years right here in my community, a $20 million school that my children are able to go to. And so that is empowering within itself because it lets you know that your voice matters. So with that being said, if I didn't have that opportunity to get my voting rights back first, I don't think I would have taken the second step to get full restoration. So I'm just telling you that, yes, voting matters to me. It's empowering. It gives me my voice. It's liberating. Now I'm able to go the extra mile. I'm advocating, like I said, for the school, for the community, for the churches, for everybody. I may even run for city council. Who knows? I'm just kidding, but I have that right now. So that's why I wanted to share my journey with you guys. And I'll turn it over to Joy to talk more about the law.
Angel, you inspire me every day whenever we talk to each other and when I see what you've done for the community and how you are a voice. It's just it makes a difference in people's lives. And so I just want to thank you for everything you've done and for sharing your story with us, because that you were brave enough to go through the two paths. And we're now going to get into it in terms of what is this that we're talking about today. We need to break down the law, and because it is so difficult, that I'm gonna ask you all to get on this roller coaster with us, and I'm gonna pull you back a little bit because this situation in Tennessee is different across the United States, and I don't think a lot of people understand that. But the bottom line is, take a look at this this graphic. It says so much to us. 2022, 4.6 million people were banned from the ballot box. And most of the time, when you think of somebody who has a felony conviction, because by virtue of felony convictions in most states, you lose your rights to vote and you lose all sorts of citizenship rights. You lose your right, as Angel said, to run for office. You lose your right to serve on a jury. You lose your right to be a fiduciary for people who want to take care of elderly family members or children. And so there are really serious consequences of that first felony conviction that lasts for the rest of your life. And in most states, you have to do something to get it back. And so when you look at this graph, I think most people think, oh, mostly the people who can't vote are in prison or in jail. But the fact of the matter is 76% are in the community because they haven't received their voting rights back. And this really hits it home. This breakdown by population is really glaring. 1% of the population lives in states where their voting rights are never lost. So there are only 2 states. I'm going to show you a map in a second where you never lose your voting rights by virtue of a felony conviction. So other than those places, those 2 states, everyone else with a felony conviction has some disenfranchisement that they have to restore or they have to have restored, either automatically or by virtue of some process. 54% of the population lives in states where voting rights are automatically restored. So upon release from incarceration, I receive my voting rights back. And so I don't have to do anything. I don't have to file a paper or go to court the way that Angel described. 27% of the population lives in states where voting rights are lost until full completion of sentence, including probation and parole. And then 18% of the population lives in states where additional action is required post-sentence to restore their voting rights. From what you've heard so far, can you predict what color we are on this graph? We are in that 18%. And here you have it. You have every state in the United States. You see Maine and Vermont, where voting rights were never lost. It's only 2 states. But other than those 2 states, you lose your voting rights. You lose a ton of civil rights when by virtue of a felony conviction. Voting rights are automatically restored in that light green color, the 24 states. And then the orange states represent where voting rights are lost until full completion of sentence, including probation or parole. And then you have the red states. The red states are the states where something has to happen and you have to do something. The individual who lost their rights has to take some action. It doesn't happen automatically at some point in time. There is one footnote, and I want to make sure that these slides are credited to the Advancement Project. They do incredible work, and we have a ton of nonprofits that are looking at this issue and really collecting data for us to help us understand this better. But these graphs were from the Movement Advancement Project. In 2023, just this August, I want to point out that the Fifth Circuit Court of Appeals said that Mississippi's law requiring that people convicted of certain felonies be permanently disenfranchised was unconstitutional. So by saying that certain people with certain felonies can never vote again, there is a Fifth Circuit opinion that I'd recommend to the lawyers out there to take a look at. The state's appealing, not shocking, I know, but this is a very moving topic. It's an issue. It's an issue that applies not just to Tennessee. But let's talk about Tennessee, because that's where we are, and that's what we're trying to figure out what has happened here today. And so in terms of thinking about Tennessee, we're ranked 48th. And this is kind of an old statistic because I think what just happened is going to rank us even worse. Based on some of the difficulties and the obstacles of restoring your right to vote, including needing to pay court costs, needing to pay child support. We're the only state in the country where individuals need to pay child support in order to be up to date in child support in order to restore their right to vote, and you have to pay restitution. And so those 3 factors have, including the complexity of our statute. What does that mean? That means 1 in 12 people, this is a Think Tennessee report from several years ago, 1 in 12 people can't vote in Tennessee. A more recent study said 470,000 estimated disenfranchised felons are in Tennessee. And that report states that 9% of the voting population is disenfranchised, but 9% of our voting population, and that is disproportionately affecting African Americans in our state.
I didn't get that.
This current process is complicated. It's very unusual. It's not something that's duplicated in other states, and it's costly. And so let's take a look at what that looks like in Tennessee and in our statutes. And again, I reiterate that we are the only state that requires child support. And this is an important topic because right now, the national trend is toward restoration of people's voting rights. When you look at these graphs, you might be surprised that 63% of all Americans believe that voting rights should be restored, that 78% of Democrats and 62% of Republicans, that is a 2018. I would venture to guess that number is even higher today. So how do we get to voter restoration? How does somebody like Angel get to restore their right to vote after they have a felony conviction? There are 2 separate paths in our Tennessee code, and it's important to understand that. So for my lawyers on here, we're looking at TCA 4029-101 through 106, and then we're also looking at TCA 4029-201. And those are the 2 main sections. So we're looking at Title 40 in Chapter 29. We're covering all restoration of civil rights. And in the 100s, we talk about full civil restoration. And in the 200s, we talk just about voting restoration. Okay, so I want to talk about these processes separately because honestly, until July, we thought of them separately. So those of us who have helped people like Angel restore their voting rights have thought about counseling our clients on two different areas. In the 100s, you can restore all your voting rights. You can restore all your civil rights. So you can restore your right to serve on a jury. You can restore your voting rights, but that involves a process. And Angel described that difficult process for her, where she had to go to court. And when I look at the documents and the petitions that we have filed for our clients, these are really documents and information that the court needs that often needs legal assistance to help somebody accomplish. And so when you're looking at full restoration, you are looking at a set of statutes that talk about it based on, and you're going to see this throughout this presentation, when the conviction occurred. So before 1986, before July 2nd, 1986, the 100 say to restore all your civil rights, not just voting, but voting's included, you have to petition a circuit court in your county of residence or where the conviction occurred, and you have to show that you have sustained the character of a person of honesty, respectability, veracity, and is generally esteemed so by their neighbors. That is the standard that you have to prove if you were convicted of a felony before 1986 and you go before a court. And there's processes you file. There's notice to the district attorney. There's notice to the U.S. attorney if there are federal charges. And so there's some real detail in these 100s. But one of the things that I want to focus on is, so most of our clients are not pre-1986 clients. They probably fall actually after 96. So there's the first chunk before 86. Then you have a second chunk of individuals who have a conviction before 96, but after 86. So if you look at the July 1st between 86 and 96, what do you have to do if you were declared infamous by a felony conviction at that point in time? You have to restore your citizenship rights. And this is interesting because it gives you who are the people who cannot ever vote in the state based on their felony conviction: first degree murder, aggravated rape, treason, voter fraud. And then this section for between 86 and 96 is a little different than everything else you're going to hear today about full restoration, because it says that a person who wants to restore based on this, in this period of time, this decade, may be issued a certificate of restoration upon a form prescribed by the coordinator of elections. And that can be given by a pardoning authority or agent or officer of the supervising or incarcerating authority. But that criteria is only for that decade. Most of the clients that I have had are after 1996. They're individuals whose conviction, their felony conviction, is after 1996. That's when they were rendered infamous. And so as a result, their full rights of citizenship can be restored through this process. So you can see there are 3 different processes, and that makes it very confusing. But the one I'm telling you about now is probably, for many of the folks on this call and for many of the folks that will help, their felony convictions will probably be after 1996. You're going to hear some differences. It's not a form. You have to go back to circuit court, just like you did before 86. And in addition to going back to court, you have to file a petition that sets forth the basis of the petitioner's eligibility for restoration. And so what does that mean? How do you well, you have to show that you've completed your sentence, and that you are now, re-engaged in the community. You can accompany your petition with records, statements, other documents. And what I'm talking about is things like, for one of my clients, we got a letter of recommendation and a letter of reference from her grandmother, from her church minister, from her neighbor, from people around her that saw that she had rebuilt her life. She did certificates while she was incarcerated and then when she was released. And we put those certificates in the petition as well. And so the idea is that you're showing to the court that you've completed your sentence and that you should be eligible to restore your voting rights. I don't know if you can notice, it doesn't have that same standard of veracity, honesty. It doesn't have the same standard that applies to somebody with a conviction before 86. This is a simpler version of what the petition should include. And I want to point out that it actually has a presumption. There is a presumption that these citizenship rights will be restored. So yes, there has to be notice by the court to the district attorney. And for the attorneys on here, I recommend that you just serve the district attorney, even though that's not required by this part of the statute. And then it has in it the notion that there will be a presumption. So can the AUSA or a district attorney file evidence that opposes it? Yes, but the judge has a presumption that it should be granted just by virtue of the fact that you have met all the qualifications for restoration. And then once you do file the petition, there isn't a specific timeline. There's a timeline by which the district attorney, 30 days prior to the hearing, must respond, and then a judge must issue an order. That order can then, according to this subsection 7, any person whose citizenship rights have been restored by order of the court pursuant to this section C shall submit a certified copy of the order to the administrator of elections, that's in the county where the person is eligible to vote, where the person lives, and the administrator of elections shall verify with the coordinator of elections that the order was issued. Upon receiving that verification, a person's voter restoration card entitling the person to vote shall be issued. So that I wanted to point this piece out to you, because in this section for full restoration of civil rights, each of the parts, no matter when you have been convicted of a felony, each of the parts ends with bringing that order to the local administrator of elections, and then bringing that to then that will be certified by the coordinator of elections. That's a little different from what the coordinator of elections is telling us we have to do today. So in terms of explaining the procedure, this section also does that, and it also clarifies where you get nonviolent offender defined. So that this part, these 100s, all govern full civil rights restoration. And right now, what Angel told you is this is what the coordinator of elections says that we have to do first for anybody with a felony in Tennessee that wants to restore their rights. But that's not what we always thought. We always thought that this was an additional piece that you could do, but that actually in 2006, when we passed the sections on the 200s, right after this, where we just talked about voter restoration and receiving a certificate, that's all we had to do. And so when we moved to this section and we talk about the 200s, that's what Angel did first. Angel came to an attorney, and she asked the attorney to help her file paperwork. She did it in Knox County. You do it with somebody in probation. In some counties, it's the clerk. In some counties, it's probation and parole. I'll show you a picture of what the certificate looks like. The person fills out the certificate, make sure that you don't owe court costs or don't owe restitution, and eventually they'll look up whether you're up to date on child support. But those were the main criteria. And once that piece of paper was filled out and submitted to the administrator of elections, it went to the coordinator of elections, and provided all those conditions were met, albeit those are serious and difficult for some of my clients to overcome. But if those were met, no court filing was required. No discretion of a judge was required. You received your right to vote back, and you were able to have a voter registration card. So when we move to this part where we're just talking about voter restoration, I want us to just start with this, because sometimes I forget if I don't start with it. Anybody with just misdemeanors, you did not lose your right to vote by virtue of a felony conviction. And I've had so many clients tell me that they can't vote, and when I look at their record, the only thing on their record is misdemeanors. Felonies from 1973, January 1973 to May 1981, you also did not. Pre-1981, you were not declared infamous by virtue of just a felony conviction. And so I want to point that out. Though if you fall in that category, register to vote. And if you have only one felony and that felony on your record is expunged, expungement restores you to the position that you were in prior to ever having that felony on your record. And so you too would not have to do the process that we're talking about tonight. So these three categories of individuals did not lose their right to vote, or if they did, it was restored by virtue of the expungement, which put them in the same position they were in prior.
And Joy, we're going to need for you to wrap it up. Okay.
Okay. I need about 5 more minutes. So in terms of thinking about voter restoration, these are the categories of people who are permanently disbarred from voting, and that category grows over time. And so I want you to just be aware of the fact that over time, the category gets bigger, but we're talking here about pretty serious felonies. In terms of thinking about where in the 200s we have to go to think about voter registration, and I've created a Dropbox for all the lawyers on here. Under the 200s, this is what dictates just the certificate of voter restoration. This is the section that says you have to pay restitution, you have to pay court costs, and you have to be up to date and current in all child support obligations. In addition, this is the original certificate of voter restoration that was in effect prior to July. The major change that occurred, we're going to hear about in 2 seconds because Blair is here with us today and she's going to talk about her case. But as a result, the coordinator of elections flipped the process. So instead of saying that you could either do full restoration or restore your voting rights through the certificate that I just showed you, now you are going to have to do full restoration first, and it says it right at the top, or be pardoned by the governor or US president, which is very, very difficult to do. And then you can fill out this newly formed certificate. And so this is a major change to the entire process of restoring your right to vote, because first you have to go to court, fully restore your rights, and then fill out this certificate. And this is contrary to who was one of our legislators, Steve Cohen, who passed the law in 2006, believed it should be. When he was asked whether the legislature intended in 2006 that they would have to do both things, he said, absolutely not. The only thing, I promise I'm going to end, Debbie, but I can't stop by not telling folks about the certificate of employability and saying this. Very recently, in the last 10 years, we added a part of the statute. If you were going to restore all of your civil rights through a civil rights petition to a circuit court, please consider a certificate of employability under 107. All of the lawyers have information about certificates of employability in their packets. And if you want more information about this, I'm happy to talk to you about it. They help with getting state licenses. They help in terms of private employers not having to worry about negligence in hiring lawsuits if you have a certificate, which is one of the #1 reason private employers didn't basically say that they don't, or they're nervous to hire somebody with a felony conviction. So there's a ton more that I could tell you about a certificate of employability, but this is the pro se form that's on the AOC website. This is what it looks like when you receive it. One of my clients was jumping up and down in court, was so moved because he was able to receive a certificate of employability, which would help him with some of the denials he's been receiving and moving him forward in his job market searches. And then this is the promise, the last thing for the attorneys on here. Under rule 6.1, pro bono, we should aspire in this state to do 50 hours of pro bono. And the reason I'm saying this, and not only that, but I can get you CLE credit for that pro bono. For every 3 credits earned at the rate of 1 hour per credit, every 5 billable hours, I'm able to give 1 hour of credit for a pro bono work that you do. And so if you work with the legal clinic or another association to help people do this, to restore their civil rights, we can also provide for CLE credits. If anybody else other than the lawyers want the resources, this is the resources I put together to help people, guide people through both of these 2 processes, both the full restoration and the certificate of voter restoration. I'm happy to share that. And for those of you who are interested in either restoring your voting rights or helping somebody restore their voting rights through this much more complicated 2-step process that has been created, please use this QR code. All it asks you is for information, who you are, whether you want to restore your voting rights or your full civil rights, whether you're a student, a lawyer, a professor, whoever you are out there. If you want to engage more, this is just going to gather information for us so that we can help more people in the coming months as we tangle with the new change. Thank you, guys. I'm going to turn it over to Blair, who is our absolute expert on how this all got started. And Blair, I think we are hoping that you're not only going to talk to us about Falls, but that you're also going to talk to us a little bit about the NAACP case. So please take it away.
Yeah, thanks so much, Joy. Thanks for all that background and your wealth of knowledge on how to do these petitions. We've never needed more expertise in that area. And thank you, Angel, for sharing your story. It's a pleasure to be here with you. So I'm going to get my screen up. And like Joy said, I'm going to be presenting on the sort of development of this case law, and I'm going to go back a little and talk about how these statutes developed and how they landed where they are now, and why the sort of that are on the table are the ones that are out there. But there's a few things that overlap with what Joy just went through. So I'll go pretty quickly through these. So I'm going to try to get this done in my 15-minute block. So as Joy said, states basically control felony disenfranchisement and their rights restoration processes. That's because of an interpretation of the 14th Amendment, Section 2, for the lawyers out there, if you want to look at that. Ironically, this clause was originally meant to allow the federal government to disenfranchise the leaders of the Confederacy. And that was really flipped on its head when states passed their Jim Crow constitutions between 1890 and 1910 with the intention of disenfranchising Black men across the states and enforcing white supremacy. So that's where these laws come from. That's where Tennessee's felony disenfranchisement law certainly comes from. And so it's important to always keep that context in mind. And so Tennessee's constitution is pretty different from many other states' constitutions in how it allows for disenfranchisement. Many states just say outright in their constitution that people convicted of felonies lose the right to vote. Tennessee's, on the other hand, allows the legislature to pass laws disenfranchising, but nothing in the Constitution itself, by itself, takes away the right to vote from somebody convicted of a felony. So the Constitution actually does guarantee the right to vote to people regardless of felony conviction status, unless the legislature has taken away that right. And in order to do that, the legislature both has to define what an infamous crime is, and it has to pass a statement of law saying that people lose the right to vote if they are convicted of an infamous crime. And that's really important for when we're talking about people who have pre-1981 convictions or out-of-state convictions, to think about if somebody is not explicitly disenfranchised by the legislature, they do have the right to vote regardless of felony conviction status. So pre-1973, the definition of, there was a list in the code that listed certain crimes that could lead to a declaration of infamy, but people didn't lose the right to vote unless a judge specifically said in their judgment that they had been declared infamous and they lost the right to vote. In 1973, the legislature tweaked the law that had the definition of infamy in it. They left the definition of infamy, so infamous crimes were still defined, but they took away the statement that said that infamous crimes result in loss of the right to vote. And as a result, between January 1973 and May 1981, no one lost the right to vote for a felony conviction. And that comes from a case in the Tennessee Court of Appeals, Crutchfield versus Collins, which again sort of laid out that proposition that I said before, that the Tennessee Constitution by itself allows for disenfranchisement, but doesn't actually enact any disenfranchisement. In fact, it protects the right to vote of people unless the legislature has taken that right away. So in 1981, the legislature, maybe realizing its mistake, having taken out disenfranchisement 8 years prior, passed a new law that defined all felonies as infamous crimes, and said that all felonies in Tennessee court are infamous crimes, and said that all infamous crimes take away the right to vote. It also passed a separate section of the code that said that in addition to crimes in Tennessee state court taking away the right to vote, felonies in federal court take away the right to vote unless someone has been pardoned by the president or their citizenship rights have been restored under federal law. And it also said that people lose the right to vote for felonies in other states' courts outside of Tennessee, again, unless their citizenship rights have been restored by the governor of that state or under the law of that state. At the same time it passed that law, it also created the court petition process that we've been talking about, an early version of that process. But going into state court and petitioning for citizenship restoration was only available to people with in-state convictions. And at this time, looking more broadly at states across the country, voting rights and citizenship rights, which also include the right to run for office, the right to serve on a jury, were rarely unbundled. They almost always came together. You lost them together, you regained them together. That was just the common way of doing it. So that's why these laws are written the way that they were. It's only in recent decades that states have started passing laws that single out the right to vote and restore that right separately from the other citizenship rights. Again, when the legislature passed this new bundle of laws, which created disenfranchisement for all felonies, and then allowed this narrow pathway to restoration for people with in-state convictions in the courts, they also tried to disenfranchise everyone that they had forgotten to disenfranchise for the last 8 years. But the Tennessee Supreme Court wouldn't allow them to do that. They ruled that felony disenfranchisement cannot be retroactive, and because people had not lost the right to vote for felonies between 1973 and 1981, they could not be retroactively disenfranchised and lose that right now, even if that's what the legislature wanted to do. And that case is Gaskin versus Collins. In 1983, the legislature updated this law one more time. They left the definition of infamy unchanged. It still means all felonies in Tennessee state court. But they, at this point, realized that it was not fair to let people with in-state felony convictions go to court to restore their citizenship rights, but exclude people who are Tennessee residents but had convictions in federal court or other states' courts. So they added language to the court petition statute that also allowed people with out-of-state convictions and federal convictions to go into Tennessee state court to seek citizenship restoration. And then correspondingly, they went to the statutes that disenfranchise people with federal and out-of-state convictions and added language saying that they're also no longer disenfranchised if they have their citizenship rights restored in the law of Tennessee. This history is dry but important because it's really relevant to what has happened recently. But an important thing to know is between 1983 and 2006, the disenfranchisement laws, the laws that take away the right to vote, remained entirely unchanged. In fact, nothing has changed about them. There is nothing in the statutes that's changed about who loses the right to vote. And again, because of the structure of the Constitution, if the legislature doesn't explicitly take away someone's right to vote, they have it, even if they've been convicted of a felony. So that's really important. Between those years, between 1983 and 2006, as Joy mentioned, that court petition process was changed a few times. There was a brief sort of certificate of restoration that could be granted by the Elections Division. They created the list of permanently disenfranchising crimes and added to that list. They had varying standards for whether or not you need to notify the DA. And because of this strong precedent against ex post facto disenfranchisement, those procedures are basically still the same for anyone who has convictions during those time periods. And that's why there's a variance in how you have to go about restoring your voting rights. And then in 2006, you get the big change on rights restoration. Again, absolutely no change to the scope of who loses the right to vote in the first place. But noting that it's really hard to go to court to get your rights restored, that it really benefits people who have access to a lawyer and who can afford to pay a lawyer, and that people who can't do that are left out, the legislature wanted to create an alternative process to allow people to go through administrative procedures to get their voting rights restored. They still left the court petition for citizenship restoration intact as an alternative way to get voting rights back, as well as the bundle of other citizenship rights. But they created the certificate of restoration statute, which entails a number of other criteria. If people meet those criteria, completing their sentence, paid off restitution, current on child support, and not convicted of one of those permanently disqualifying crimes, they could theoretically go to a probation officer or the governor's office and get a certificate filled out that certifies that, and then take it to the elections office and register to vote. We'll talk a little bit more about how that played out in practice, but I wanted to look at some of the challenges, the litigation that has been brought over the years challenging this law. So after the new law was passed in 1981 that disenfranchised people convicted of felonies in Tennessee state court and most people convicted of felonies in federal and out-of-state courts, there was a challenge to the law in Wesley versus Collins under the Equal Protection Clause and under the Voting Rights Act. And this case basically alleged that the statutes were passed with racially discriminatory intent and had a racially discriminatory impact. The Sixth Circuit did not agree with the plaintiffs in that case. The next big case was in 2010, Johnson versus Bredesen. So this is after the certificate of restoration process was created. This case challenged the requirement that people would have to pay back restitution and child support in order to get their voting rights restored. Basically holding that this, saying that these obligations are a modern day poll tax and that they discriminate against people who cannot afford to pay those debts back. The Sixth Circuit found that the requirement should be analyzed under rational basis review because people who have been disenfranchised do not have a fundamental right to vote. So importantly, they held that these statutes, like I said, are rights restoration statutes, not disenfranchisement statutes. So they're analyzed under rational basis review, not under strict scrutiny, even though if they were disenfranchisement statutes, they might invoke the fundamental right to vote. They also rejected the claim that legal financial obligations are poll taxes. And they rejected the claim that these new requirements to pay off restitution and child support that were created in 2006 would create ex post facto disenfranchisement. And that was because they held that felony disenfranchisement in Tennessee was not punitive. Shortly after this case was resolved, the legislature went back and reopened the law and added a requirement that people have to pay off court costs. So the legislature's response to this case was to make it more difficult for people to get their voting rights restored and add additional barriers. This is a very weird case, a Court of Appeals case in 2016, which held that, again, remember that we have these two alternative processes, getting your citizenship rights restored in court or getting a certificate of restoration. In this case, somebody got his citizenship rights restored through the courts, and then he went to register to vote and was denied voter registration because he had outstanding court costs. Outstanding court costs are a requirement of the certificate of restoration process, but not of the citizenship restoration process. So they're required for the administrative certificate, but not if you go to court and ask a judge to restore their voting rights. But this case held the opposite. This case held that the certificate of restoration requirements have been imputed onto the citizenship restoration process. Now, this case has been around since 2016. I don't know how it actually plays out, and Joy could probably speak to that. But this case is on the books in the Court of Appeals. So this is a pretty contradictory opinion, again, because these processes were created as alternatives to each other. Moreover, restoration of citizenship includes the right to vote. So how can you get your citizenship rights restored if you don't have your right to vote restored? But this is really a precedent that I think was built upon in the new guidance. So now I'll talk a little bit about one of our cases, which is ongoing in federal court. We've described the certificate of restoration process, which theoretically says if you meet certain eligibility criteria, you can go to these certain set of officials, probation officers, or the governor's office. In the statute, in practice, court clerks also will fill these out and ask for your certificate of restoration, and they'll just check your records and make sure you're eligible, and then they give you the certificate, and then off you go to register to vote. That is not at all how it works in practice. Our friends at Think Tennessee made this fantastic chart, which sort of shows actually how complicated the process is. The left side shows whether helps somebody determine whether they're even eligible for the certificate, and then the right side sort of shows some of the procedures you have to go through to actually get the certificate. What we found from working with Dawn and Three Hearts for almost 6 years is that many people who are eligible cannot get their certificates. Most people can't get any sort of determination whatsoever as to whether they're eligible. And a lot of times people are just given wrong information. So what you end up with is a system that is inaccessible, error-ridden, opaque, and inconsistent. Through discovery in this case, we found that what we assumed was true is true. There's almost no training for these officials who are supposed to fill these out. A lot of them have no idea what this is. There's no uniform guidance for how to interpret the rules. They don't keep records. One official keeps records on Post-its of who's asked for these, and then as she moves through the application, she throws away the Post-it when she's done with it. There's just nothing going on with these that would allow you to vindicate such an important constitutional right. And worse yet, there's no way to appeal. If somebody tells you that you're not eligible for this, you're out of luck, basically. Or you can keep advocating and try, and if you think that you're eligible, keep pushing for it. But the downside of that is that people have been prosecuted for advocating that they're eligible and ending up getting a certificate that says that they are when that is incorrect. So this system is really designed to fail. It's full of errors, and the burden of those errors always falls on the voter. So our lawsuit alleges that the system violates procedural due process. This is an important right that's been created by the state, and they've done absolutely nothing to make sure that it works. Another piece of this case relates to people who have the pre-1981 or pre-1973 felony convictions that didn't disqualify them from voting. The state's policy has long been that those people have to go to the courts and get their old court records and bring those to be able to register to vote, which is absolutely absurd because these records are often over 40 years old and they might not even exist anymore, and they're in the custody of the state, and these people never lost the right to vote. So that's a violation of the National Voter Registration Act. And then this is the last one, I promise. I know I'm at time, but this is the most important one, unfortunately. So Falls versus Goins is a case that we brought in 2020 on behalf of Ernest Falls, who lives in Bean Station. And this relates to the issue with out-of-state convictions that I mentioned earlier, which is that the statutes since 1981 have only disenfranchised people with out-of-state felony convictions unless they have been restored to citizenship by the governor or other appropriate authority in that state or under the law of the state of Tennessee. So in 2019, we were working with several people who had out-of-state convictions, and we wrote a letter to Mark Goins, the director of the Elections Division, trying to get clarity on this. And we asked, okay, it looks to us in these statutes like people who have had their civil rights restored out of state have the right to vote. They're not disenfranchised under Tennessee law, so they don't need certificates of restoration. The Elections Division wrote back and said, yes, you're correct, and your clients have the right to vote. Then in 2020, the Elections Division sought an Attorney General opinion saying the opposite. And the Attorney General's office issued an opinion saying that everybody had to go through the certificate of restoration process or comply with the certificate of restoration eligibility criteria, even if they had had their civil rights restored out of state. Basically, getting your citizenship rights restored out of state made no difference for these people. Our client had been granted that clemency in Virginia, the state where he had his felony convictions, but he couldn't show that he didn't owe court costs. His case was decades old. It was the middle of COVID. He just couldn't get those records. So his voter registration was denied. So he brought suit, and this case worked its way up to the Supreme Court. And this year in July, the Supreme Court issued its opinion agreeing with the state's position that Mr. Falls had to comply with the certificate of restoration statutes. He had to show that he did not owe any court costs in order to register to vote. The court was very careful to limit its opinion to the facts before it. It even said that it wasn't sure if that opinion would apply to people who got their civil rights restored in the state of conviction and then moved to Tennessee. So they were very careful to limit this opinion. But shortly thereafter, the Elections Division issued new guidance that entirely upends the rights restoration process, undoes the will of the legislature to create an alternative, non-discretionary voting rights restoration process, and are now requiring that everybody first get their citizenship rights restored, either through the courts or by getting a pardon from the governor, and then seeks a certificate of restoration. This guidance makes no sense. We view it as vindictive. We think that this is retaliation against these court cases and against the work that's been done to re-enfranchise people across the state. And we think that it will eventually be found to be incorrect, whether that's through the legislature or the courts. But as of now, this is the new rule, and we're going to do everything we can to help people get through this process. I think, is Dawn next?
I think Kathy's going to take on the lead, and I just wanted you to know, to save time, we've been dropping bios in the chat. Blair, you've done tremendous work to help us on these cases and to just contextualize some of the I have found very obtuse case law. So Kathy, from the League of Women Voters, who leads the voter restoration project in Tennessee, has some important stuff to share. Kathy, you're muted.
Thank you. One more button to push. I am really so pleased that I can follow. Let's see, I got to go back here a minute. Won't let me. Oh, sorry, it's not working well. Let me get back here. Okay, I'm going to report on our report, the Still Locked Out in Tennessee, the survey of county officials charged with implementing the Tennessee process for restoring voting rights to individuals convicted of felonies. You can download the report. There's the URL, or you can write to me if you have questions, or you can put them into chat as we have time. And let's see if I can't go to next one here. Our members conducted 20-minute phone interviews using a series of questions from the survey we created. Many officials declined the opportunity to participate. The probable reasons for this refusal are included in the full report. Perhaps we can discuss later, but we did get a fairly equal distribution, including 30 of our 95 counties, officials from those, and also by population size from very small to much larger counties. Our study took place in 2022, prior to the major roadblock added just this summer, but our results are still relevant because the certificate of restoration process, the core process for restoring voting rights, has not changed, at least as best as we have been able to learn, even though the actual certificate form looks a little bit different. It's not that different, and we still find the same kind of officials are supposedly still involved. Now, although probation and parole officers play a primary role, they have some records that are needed for certification on the certificate, but we were unable to complete interviews with them. From this point on, I'm going to use the term administrator to refer to administrators of elections or their designated staff members responsible for providing services. And I'll use the term clerk to refer to criminal or civic court clerks. For those of you that don't know, Tennessee's larger cities have a criminal court clerk. but other counties use a circuit court clerk to manage criminal records and payments that are part of the sentence. Now, I will also refer to the certificate of restoration process as the core process. As we look at some of the findings in our recommendations, I will also refer frequently to the important U.S. mandate of due process. For those of us without a legal background, we can look at due process as involving and providing balance between powers of government, that is, the established rules and procedures carried out by the law, supposedly, and protection of individual rights, such as equal treatment by officials and access to essential information. We'll be coming back to this as we go forward. One question we particularly wanted to explore was, what is the professional stance of these officials? By professional stance, we mean how aware are officials of their role as public servants to carry out their duties and to understand the need to provide fair and equal treatment to the public. In other words, to provide due process. Many officials we interviewed throughout other state offices were responsible for assisting people with specific needs. For example, a clerk told us their office duty is only to process the core form, not provide first step assistance. All clerks that we interviewed said they were responsible only for providing information about convictions in their own county. An administrator listed his duties as telling people about the core form and who to see in their county, but not who to see in other counties or the federal court. He included that he helps people determine if they're eligible to apply, but his duties did not include ensuring people knew or could find essential information and options. I do want to make clear that we found little evidence, just as Blair mentioned, that officials received in-depth training related to the core process or due process, and most officials reported very limited guidelines were made available in their office to people wanting to restore their voting rights. Many officials talked about brochures or handouts and a website that they provided, but when we checked, these seemed to come from the Secretary of State's website directly, and I have found to be good information as far as they go, but you have to know where to click and how to go deeply in order to find what you really need to know. Overall, responses from officials demonstrated their sincere desire to help people restore their voting rights, their confidence that they were doing what was assigned to them by the state, and their awareness of many other duties that distract from providing assistance to people beyond simple duties about the core process. Yeah, we analyzed our participants' responses to determine if they fully understood the process. And that cartoon I just showed you reflects the comments of some of the officials and many disenfranchised people that we've heard about who don't know where to turn. Indeed, many county officials we interviewed appeared to lack information needed to fully inform individuals of their legal options, a major aspect of due process, as well as their role in helping people overcome avoidable obstacles to re-enfranchisement. Although the state provides instructions for completing the core, these instructions are vague about who certifies what on the form, and this is still the case now. It leaves counties having to interpret the instructions, and therefore not all counties are doing the same thing. Definitely not. People need to know who is going to certify what on the core form and whether they can get signatures electronically or need to go physically to specific offices. We found a lot of variance from county to county. Some counties allowed clerks or probation or parole officers to certify all items on the core, but officials in other counties believed a probation or parole officer had to sign some items and the clerk had to sign other items, and people had to take the form to each of these officials and in a certain order. Imagine the confusion if a person isn't told about this procedure, which may not be the same in another county where they may also have convictions and need a separate core signed, because yes, they have to get one for every court record that they have that's a felony and is keeping them from voting. Imagine also how difficult this can be for people who must travel to another county and don't have adequate transportation or if they miss work, do not get paid. Child support payments is another area of confusion. A few years ago, the Tennessee legislature passed a law requiring, where applicable, that people in current child support payments, that people be current. So the Secretary of State added a statement about this requirement at the bottom of the instructions for completing the certificate of restoration. They stated that the coordinator of elections will verify with the Department of Human Services that the person is current on child support. However, no certification is required on the core form itself. One administrator, well informed about the core instructions, stated, an applicant doesn't need to know if they're current on child support, as the Secretary of State's office will look up that information in the Department of Human Services files. While this is true, this creates a potential problem because the person will be denied voter restoration if not current in any owed child support payments. And there's no standardized appeal process. While some officials knew where people could find this information before they submitted core, many officials did not know, nor did they think it was their responsibility to know. One clerk stated, child support never comes up in this office. Child support has nothing to do with restoring voting rights. Some officials did not appear to be aware of the law about the waiver of indigency as well. That remove all or some court costs and fees for very low income people. And it is included on the core form, but they were not aware. People need to know that they may qualify and about options that can make all the difference in their success. And another official responded, I don't think people can restore voting rights if convicted of a felony unless it is expunged, which is not true, as I believe Joy was sharing with us. So here we see the list of unknown unknowns, the essential information and options that many seeking voter restoration do not know to ask about. And I'm not going to, I've gone over a few of these. I won't go into all of them. I'll come back to some of them a little bit later. But the next two slides present graphs that help us understand the degree to which officials told us they provide essential information and options that might help a person succeed. This graph represents the percent of 11 administrators who inform people about 5 of these important options, and you can see those down at the bottom of the graph. 50% or more reported they did not tell people about these options and or did not believe it was part of their responsibility. Only 27% reported telling people about the law regarding an affidavit of indigency, and another 9% if the person knew to ask. But many people seek first information about voter restoration from an administrator, and therefore need to get that information at that time. Payment of LFOs, which is legal financial obligations, is of course a major obstacle in restoring voting rights for those with limited funds. People need information about options at this initial stage, or they may just give up. If they're put on a payment plan and miss payments, they face a penalty in many counties of loss of driver's license. For due process to work, administrators of elections need to help people understand all options and their implications. Here we see the percent of 24 clerks and the degree to which they inform people about the 5 types of options and information they may need, or whether they don't think it's their responsibility to do so. Only 43.5% told us they tell people about expungement, something that may be very important if their felony convictions are categorized at a lower level, or if records contain inaccurate or incorrect information that could keep them from restoring voting rights. But another 43.5% said they provide this information only if people know to ask them. 38% of clerks reported they do not share information about affidavit of indigency and how a person can petition for that if they are of a very low income. And another 17% share this information only if asked. And as one clerk told us, they don't tell them unless they ask, because then their court loses money. We learned that there is no list of state-approved court costs and fees, and the money collected helps fund the county's court, which represents a potential conflict of interest. 48% of clerks said they did not tell people about the child support requirement. When people need to know how to obtain records from other counties where a felony conviction occurred, almost half the clerks said they did not tell them and didn't see it as their responsibility. More about that in a minute. 61% of clerks told us they tell people about their legal financial obligations, but 17% said only if they ask, and 22% said they do not provide this information, which is puzzling since their office has this information. It seems reasonable that the appropriate type of county official should be able to search for court records across the state and perhaps beyond and in federal court. But that is not the case in Tennessee. We have no statewide database. Each county has its own electronic database for more recent convictions and paper copies on or microfiche that must be searched if, in many counties, the records are older than the 1990s. 37 of our 95 counties have uploaded a link to their county's records on our website called the Tennessee Public Court Records System. This clearinghouse does not include 3 of our 4 highest population counties, but it is a way for people to more quickly access information. Further, the Secretary of State staff member who makes the final decision about whether to restore a person's rights did not share, at least at the time of our survey, how she finds information. Now, there are many private organizations can be found online that provide a way to search criminal records, but most charge a fee and may or may not have complete or accurate records. Here are 4 main findings. Inconsistent procedures across counties, inconsistent explanations of legal requirements and options, inconsistent interpretations of legal financial obligations, and lack of access to accurate and complete criminal court databases by officials and people seeking voter restoration. Based on these findings, it's easy to understand why only 5% of people in Tennessee successfully restore their voting rights. The other 95% remain in a permanent subordinate status as citizens, which many experts report leads to recidivism and return to prison. When very low-income individuals are uninformed that they can petition for an affidavit of indigency that could waive court costs and fees, due process fails. When individuals are uninformed that they may qualify for expungement of some court records, due process fails. When officials assigned duties as part of procedures in the core process are not well informed, due process fails. Without due process, the rule of law is broken. Here, our survey findings have led us to the following recommendations to improve due process in Tennessee's procedures for voter restoration. These recommendations update those in the report originally posted on the League of Women Voters Tennessee website. Number 1, ensure officials understand the core process and how to best provide equal treatment to all who seek voter restoration. Number 2, ensure individuals receive clear and accurate explanations about essential information and options available to those who qualify. Number 3, ensure individuals receive comparable services in all counties, criminal circuit courts regarding legal financial obligations. And number 4, ensure equal access to accurate and complete criminal court databases and provide assistance by officials to complete searches of criminal records held in Tennessee county court clerks' offices, federal courts, and in other states. I should add that one of the reasons these are needed so much is, as Angel pointed out a bit, it can be very traumatic to have to deal with all that went on with your criminal convictions, and very so traumatic that many people don't keep any records that they might have, don't even recall perhaps in what county they actually were convicted especially if it's multiple convictions. And therefore, it's very important that there be a way to help them to access their information. So what now? How can we bring about positive change about voter restoration in Tennessee? Here is Don Harrington, Executive Director of Free Hearts, to tell us how we can join them in bringing about positive change. That's all yours, Don.
Okay, I was trying to get my slides up. Give me just 1 second. Oops. Okay, can you hear me?
Yes.
All right, so my name is Dawn Harrington. I'm the Executive Director of Free Hearts. Free Hearts is a Tennessee statewide organization that's led by formerly incarcerated women that provide support, education, advocacy, and organizing families impacted by incarceration. And our ultimate goals are reuniting families and strengthening communities. So being that we are led by directly impacted people, voting has always been very paramount to what we are doing at Free Hearts. In fact, when we first started working with folks on their voting rights and working with Campaign Legal Center, I didn't have my voting rights back at the time, and actually through learning the process was able to figure out how to get my own voting rights back. And so you know, with us, we always feel like there's always something that you can do. And so I'm just gonna speak just a little bit on strategies for change, what individuals, organizations, and attorneys can do. And just naming that this list is not exhaustive, it's meant to mostly like spark some ideas. The main thing is know that there is always something we can do, and we have to keep fighting, because at the end of the day, you know, our democracy is at stake here in Tennessee. And so there's always something that we can try to do. So I just put together a few of the things that you can try to do. So, for example, individuals can text-a-thon. We've been having regular text-a-thons, texting Tennessee voters to let them know about the rule change and ask them to take action. Specifically, Governor Lee can do like Governor Kim Reynolds and other governors have done, and restore voting rights en masse with an executive order. And so we've been letting Tennessee voters know about the rule change and asking them to contact the governor with our easy online tool. So our next one is this coming up Wednesday at 6 p.m. Central, 7 p.m. Eastern, if anybody wants to join. Also, you can take action. You can create or sign a petition. Like I said, write the governor, contact your legislator ahead of next year and tell them, you know, you really want them to work on this. Or you may think of other ways to take action. But the main thing is a body that's in motion stays in motion. And so we need to, one, make sure that the greater community across the state of Tennessee knows about this change and how egregious it is, because what we've been finding is a lot of people don't actually know that this even happened because it was so quiet and so quick. And so we need to let people know, and then also kind of get them to join in the fight to restore voting rights. Also, like media or events, you can write an op-ed, letter to the editor. In fact, we have a template for a letter to the editor if you want to use that and edit it, and send it into your local paper. You can also set up a local event to just help raise an awareness, because again, a lot of people don't know about the change and really, you know, how this really is impacting the state of Tennessee. So a few of the things that organizations can do: organizations can tell your network about the rules change, you know, tell your list, start a sign-on letter, get sign-ons, contribute research, as we've seen so much wonderful research today, educate the community, spread the word across the urban and the rural divide, because it's important to not only, get the word out in the major cities, but especially when we're thinking about, this being rolled out across the state, it's also very important to get the word out to the rural community. So just think about like who you have in your network, how you can get that word out there to make sure that everybody knows so that they can be interested and engaged to get involved with the next steps. Also, organizations can host an event like this wonderful event, a press conference, have press come out, a webinar, anything to basically help spread the word about the rule change and give people ways that they can get involved, that they can sign up to hear about next steps, so they can hear about what's going on at the legislature or whatever the case may be. Just, trying to create a list of people that really care about this. Also, people will likely say, hey, I need my voting rights back. And, if you don't work on it, then you can get with Joy, ourselves, at Free Hearts, Blair, and we can definitely help. And we're all putting our heads together to actually try to figure out, an infrastructure that can really scale this more widely as well. Also, we have a Free the Vote coalition, where, the Legal Women Voters Campaign Legal Center is a part of it, Free Hearts, and several other organizations. We meet weekly at 5 p.m. Central, 6 p.m. Eastern on Wednesdays to strategize and align strategy towards policy change on voting restoration and voting from jails and prisons. We also have a listserv, which is a Google group, where even if you can't commit to like coming to the calls, you can still be a part of the listserv and send your updates or see the other updates that are coming in on the listserv. Some of the things that attorneys can do, as was already mentioned, pro bono assistance is a big need when it comes to this. The process of the restoration of citizenship rights is, it is very particular. It's steps. Definitely need attorneys to assist with it. So we need attorneys to assist with restoring rights to vote, as well as if you have students that want to get involved, a law clinic. But we also could share between the attorneys that are working on this, like information in one database, so that we can all be aware about how this is rolling out, and be able to figure out some next steps from there. In addition to that, policy, legal research for legislators and or litigation efforts, and just working together with other attorneys as thought partners on the next step. And spoiler alert, we will have a space for this at the Free the Vote convening as well, which I will go to next. So last but not least, I mentioned this already, but the Free the Vote Coalition meets each Wednesday at 5 Central, 6 p.m. Eastern. It's only 1 hour, trying to get people on and off so they can keep coming back. And if you want any more information or to get added to the calendar invite or to the Google group, just give us an email at info@freeheartsorg.com and or AIMEE@freeheartsorg.com. Shout out to Amy, our legal administrative assistant. And we're also, the coalition is having a convening on September the 24th and September the 25th. That's a Sunday and a Monday. And September the 24th is for directly impacted people only, where we're just going to have a space to really think about this, to talk about testimony, to really think about what we want to see in policy and things like that. And then the 25th, that Monday from 11 to 6 is for everybody. This is in from 11 to 2 is going to be like in a big group, strategizing and thinking about this, trying to come up with an aligned strategy. And then from 2 to 6, there's going to be breakouts, one for lawyers and legal strategy, and the second one is for grassroots and organizing strategy. And so we do have transportation and lodging available for this. So the registration is bit.ly/Free the Vote strategy. We would love to see you there. So in conclusion, again, this was not an exhaustive list of things that you can do, but hopefully it, got your wheels to turning and has you thinking, there are things that we can do. And so we can put our heads together and work together to free the vote in Tennessee. Thank you.
And thank you, Dawn, for that. And I think we have just a little bit of time left for some questions that haven't been answered, but I'm wondering, Joy, do you want to just mention something about the CLE credits and how that's handled?
So for anyone who's signed up for CLE credits, I'm supposed to wait till 5 minutes before the end of the session to
okay, we're
share
very
the link.
close. We're fine.
So I'm about to share a link. Just fill that out. If you haven't applied for CLE credits, but you would like them, I can also send you a registration. I'll also put a registration link into. I think we can arrange for it. So stay tuned in like less than 2 minutes.
All right, thank you. I didn't know about that. And I know that the panels have been responding to questions as we've gone along. And one of the questions I said I didn't know if it was answered was a question was raised about the name of the form to get job eligibility back. And that was what you had mentioned, Joy. You want to?
A certificate of employability is what I was talking about, and it is under that 107 part of chapter 29. I'm looking for the question. Debbie, do you remember the exact
It was
question?
Alice Petty. It's back a ways around around 6:30 on the time.
So what was the name of the form? Yes, it's a certificate of employability. I'm gonna send the link to the form in the chat, but if you want to talk more about how to do that, how to file for one of those, I'm happy to talk about how we've done it and what type of evidence. There is kind of a standard for evidence that you have to show as a part of the petition. You can do it with one petition for full restoration and certificate of employability, so you kind of wrap it up all in one, file it for the circuit court. We didn't talk about filing fees, which I had on my list, but I just didn't get to. Every county has a different filing fee for certificates for full restoration petitions, and you could pay one filing fee for both things if you pull them both together, applying for full restoration and certificate of employability. And we're also working on helping people figure out how to ask to suspend that filing fee until the end of the actual court case. And there's good statutes that say that they can suspend when you file that initial fee, which ranges from anywhere between $100 as the statute lists to, I think in Knox County, it's $209. So if we can talk to you a little bit more about suspending it and then what happens after that. Some clerks are putting people on payment plans. Some are just holding it and not doing anything in terms of requiring payment. So I would love to talk more to anyone who's interested.
So if there are additional questions, if you could just post them now. I think we've answered all of them, but actually I do have one question, which I'll just sort of throw out to all of the panelists, which is, have any of you heard of any interest legislatively in addressing any of these issues that came up as a result of this year's court case? And the fact that nobody's responding to that one, I think probably means that we haven't heard anything yet. Dawn, have you heard something?
Well, I've heard something about it, but I don't know, it's rumor, so I'm not sure how, so I don't want to really give that, but I heard something. But definitely at the Free the Vote convening, we're going to be putting our heads together about legislation for next year, because it is going to be important to have a legislative effort around this top of the session.
Okay. Oh, and I do see another question that's here, which is, how does the loss of citizenship and voting rights in Tennessee impact the rights of U.S. citizenship? Does anyone want to take that question? Okay. Well,
I can speak to that pretty vaguely, but there are some federal statutes that will allow for deportation of naturalized citizens or people who are on temporary visas or undocumented if they're convicted of felonies. But I don't know how restoration of citizenship under the law of the state would impact those rights or those proceedings.
Okay. Okay. All right. Let's see. Oh, and was one other question. I don't know if it had gotten answered from Curtis Dush. I have a friend in Kentucky who has organized clinics to help by bringing together all the folks needed to navigate this process. Does Tennessee do anything like this? It seems like it would be helpful for folks who have transportation or other access issues.
So we have done this around expungement, and I feel like we're using our model that we've used for expungement to figure out how to extend it. So one really exciting thing is that Tennessee Supreme Court's Access to Justice Commission named voter restoration as one of the priorities for their October pro bono month. And so one of the reasons that we'd love to know if anybody on this call on the Zoom either needs assistance or would like to explore free pro bono help, or if you're a lawyer who wants to be able to do this for clients, our goal is to have a pilot project to train lawyers at the end of September, early October, and then to move from that training to a small project that has both in-person and on Zoom. So in-person clinics in 3 major cities, and then Zoom clinics for folks who are in rural areas where there might not be the level of access to lawyers. And so we are just kind of pulling that. We wanted tonight to be the info session where we're actually providing information to everybody. But if you fill out, and the last thing I'll share is that QR code again. If you fill out that QR code, we'll loop you into that project and can give you more information about how to get involved. And there's all sorts of levels of involvement for law students, for lawyers, for professors, for actual individuals who want help and want to help others because you know how hard this process is. So if you just give us a sense of who you are, well then, I mean, what Dawn was saying about trying to really make a true statewide effort, I think that's our goal. And it's going to be tough going, and we're going to make some mistakes, but I think our real push is going to allow us to learn a ton and to hopefully make some real change.
So, and I can see that we're running out of time now. So I did want to say that the League of Women Voters will send out a recording of this session to everybody who signed up. And we will also include with it contact information for the speakers today, should you want to get in touch with any of them for further information. So just wanted to let you know that there will be an option for that. And obviously, I can tell there's a lot of interest, and we'd certainly like to make sure that everybody who has an interest in being involved in moving forward on this project has the opportunity to. So I think, Joy, we're ready for you to make your announcement about the CLE, and then we will wrap it up for the evening.
I shared the credit. I shared the link in the chat. Basically, it says if I shared 2 links. So if you want CLE credit, but you didn't sign up, register first and then fill out the link for the actual CLE credit. So can everybody see the link for getting CLE credit, just to say that confirmation of attendance? When you click on the link, it should say confirmation of attendance.
Okay. Yeah, I think that worked. Okay. Well, so I think thanks again to our panelists. This has been extremely informative. I've learned so much more than I did before, and I thought I knew a lot on this topic. So I thank all of you for sharing your time, and I thank all of our audience for your interest in this very, very important issue that really impacts all Tennesseans, because when we ignore 9% of the population, we're ignoring an important part of our collective voice, and we'd really like for them to be involved in our communities. So thank you to everyone, and good night.